The topic for today's lecture is the need for differentiation of the domestication of African Union treaties and other multilateral treaties in national law. It is my pleasure to introduce our first distinguished speaker, Judge Abdulqawi Yusuf, who has served as a judge of the International Court of Justice since 2009 and as vice president and president of the court. As you may know, the court issued a historic advisory opinion just this week on climate change, which will have great consequences for all of us and for generations to come. Judge Yusuf has had a distinguished career as a jurist, diplomat, and legal advisor to various international organizations. He is the author of numerous books and articles on a broad range of topics of international law that are important for Africa. He has taught and lectured at universities around the world, beginning with the Somali National University. Judge Yusuf is the founder of the African Yearbook of International Law, the African Foundation for International Law, and the African Institute of International Law, under the auspices of which this seminar is being conducted. I have had the pleasure of working with Judge Yusuf for more than a decade to promote the teaching and dissemination of international law for the benefit of Africa. It is indeed a great pleasure for me to give you the floor. Judge Yusuf, you have the floor. Welcome.
Virginia, I thank you very much, and I thank you for organizing this series of seminars because they are extremely important, and I think that many African lawyers and international lawyers will benefit from them. And you said that we have been working together for more than a decade. I think it's almost 2 decades, because I have been at the court for the past 16 and a half years, and I have worked with you even earlier than that, especially on the audiovisual library of the United Nations, for which I recorded a couple of lectures. But I think that this series of seminars are going to enlighten the participants on many aspects of the relationship between international law and African law. And I will come to maybe in a few minutes what I mean by African law. Maybe different people mean different things when they talk about African law. But I will come to that in a minute. And I'm very happy today to speak about the need for differentiation between international law and the incorporation of international law into domestic law, to differentiate it from the incorporation of African law or the public law of Africa or African Union law into domestic law in Africa. When you look at the relationship between international law and domestic law, what you will find in most African constitutions is reference to international law. You will never find in African constitutions reference to the legislative enactments of Pan-African institutions. But we cannot ignore, after 60 years of independence, the growing number of legislative enactments by Pan-African institutions. And today, there are 80 of them when I last counted them. 80 such legislative enactments from 1963 to 2025. And these enactments reflect two types of African law. And for me, it is actually those two categories of enactments which compose what we refer to as African law. The first category, or maybe one could refer to it as Pan-African law. The first category is the category of legislative enactments which concern the Pan-African institutions, and they create institutional law. And one can call them the law of the African Union, the law of the Organization of African Unity, the law of Pan-African institutions, etc. But that is the institutional law of Pan-Africanism. But there is another category, which for me actually is much more important. And that second category is what I call the public law of Africa. Some scholars call the regional law of Africa. But I prefer to call it the public law of Africa because it is not simply a matter of a region of the world, because there are many regions of the world which adopt this certain legislative enactments to govern the relations among the states of that region. For me, what is particular, what is really special about the public law of Africa, is that it is based on certain shared values grounded in Pan-Africanism and in the history and development of Pan-Africanism. Because without those shared values, we would never perhaps have the type of institutions and the type of enactments that we have in the African continent, which you may not very often find in other continents of the world. So the public law of Africa for me is a reality which is based on Pan-Africanism and for which the Organization of African Unity first and later the African Union has been legislating. And those are the instruments that actually matter most as far as the peoples of Africa are concerned, because they are the instruments which talk to them, which address their rights, which address their aspirations, which address their Pan-Africanist outlooks. And here I'm talking about instruments like the African Charter of Human and People's Rights. I'm talking about the Maputo Protocol on Women's Rights. I'm talking about the Charter on the Child, or the I'm talking about the Charter on Democracy and Good Governance. I am talking about all those African instruments which refer to the common values of Pan-Africanism and which are meant to promote those common values and to codify them into law, because that's the most important thing. Because you can have, of course, all kinds of shared values, but if you don't codify them into law, they do not have a direct impact on the everyday life of people. But when you codify them into law, then of course you need that law to enter into force. You need that law to be implemented in the national legislations of the member states of the African Union, for example. You need that law to be integrated into their domestic legislations. And that is the reason why I am talking today about this differentiation, because you need also differentiation between instruments which are negotiated and concluded at the multilateral level, at the United Nations level, at the international level, to which African states accede or adhere or ratify, etc. And the legislative enactments of the African Union and the Organization of African Unity before it. We cannot simply continue. If we are serious about Pan-Africanism, and if we are serious about building together a Pan-African approach and a Pan-African legislative enactments, we cannot simply continue to say that the African Union legislative enactments which constitute the public law of Africa or even the institutional law of Africa will be treated by member states in the same way as multilateral treaties of the United Nations. Imagine, and just look at this. How far is the distance between the legislative enactments made in Addis Ababa or in other African capitals for African states and multilateral instruments that are negotiated in Vienna, Geneva, or Montego Bay, the Law of the Sea Convention, etc. One is at the universal level, the other one is at the African level. So why do we have to treat what we conclude at the African level and for the purposes of harmonizing Pan-African legal approaches and harmonizing Pan-African policies, why should we equate it and treat it in the same way as multilateral instruments, which concern the entire world and which concern all states in the world? So if we treat them the same, then what is the purpose of having these regional institutions which we claim to reflect some common values and some commonalities which we share as Africans and as the peoples of the African continent? Commonalities which flow from our history, which flow from our struggle for freedom, which flow from our struggle for emancipation, which flow from our fight against slavery and against colonialism, which flow from our aspirations for freedom as peoples of the African continent. So I think that it is time that there should be a difference and a different way of integrating into national legislation these different types of instruments. And of course, what we are talking about, as I said earlier, is the relationship between international law, African Union law, or the public law of Africa, those two sets of international legal instruments, and the constitutional laws or the domestic laws of African states. And so we all know, and we are acquainted with the constitutional provisions and the manner in which international legal instruments of a multilateral character or a universal character are incorporated into the domestic legislation of African countries, because it is the African constitutions themselves that tell us. And you know what? What is actually surprising is that the African countries that from the time of their independence, and even before that, always had some sort of hesitation, some sort of doubt about international law in general. It is surprising that today you find at least 7 or 8 African constitutions which say that the rules of general international law are part of the law of the land. And I ask myself, and I put myself in the shoes of an African judge, a judge at the Supreme Court or the Constitutional Court of an African state. And I ask myself, would such a judge really know what are the rules of general international law or the rules of customary international law, which are part of the law of the land of his country? Which would he take? You know, when we normally talk about the sources of international law, I'm quite sure that you are all acquainted with the fact that we are talking about Article 38 of the Statute of the International Court of Justice, because that is the best guide that we have at the international level on what are the sources of international law. And there, of course, what we know is that Article 38 says, first of all, there are the conventions which are established, which establish rules accepted by states. And that is, of course, what you also find in African constitutions, that agreements or conventions which are negotiated or concluded by African states will be incorporated into the national legislation, the national legal order or the domestic law of the country. Although, of course, different African constitutions have different approaches, and they have different ways of carrying out that incorporation. But at least as far as conventions are concerned, they have a system, mostly through legislative approval, most of them through legislative approval and publication. And of course, they refer to that as ratification. Those ratifications are sometimes carried out by the executive, sometimes by the legislature, sometimes by both of them. But they are recognized in most African legal systems. But that is not the only category of or the source of international law. There are the international custom or customary international law rules, which are an evidence of a general practice accepted as law. A general practice accepted as law. And that's why I was asking myself, when the judge at the national level, whether it is at the Supreme Court and at the Constitutional Court, is confronted with a rule in the constitution of the country, which says that the rules of general international law or of customary international law are part of the law of the land, how would he know which rules are accepted or constitute an evidence of a general practice accepted as law? Because when you say accepted as law, there must be a conscious acceptance by states of that rule as a general rule or a customary rule of international law. And the reason why I am surprised also is not only for this. The reason why I am surprised is that immediately after their independence, the African states made it very clear at the international level that, number one, they could not subscribe to and they could not accept what the European nations in the 19th century developed as customary law amongst themselves, and to which they referred as the jus publicum Europaeum, but sometimes as customary international law, but which was a law applicable among a closed club of states, mostly in Europe, which considered themselves as civilized nations, and therefore excluded from its application countries in Asia, countries in Africa, and many countries even in Latin America, although most of those countries were now run or ruled by people of European descent. So the African states said, we were not party to the creation of that kind of customary international law and general international law, and therefore we will have to study what we can accept and what we cannot accept. And there was, as a result of that, and because also of the fear that as members of the United Nations, newly independent African and Asian countries may actually reject in block what the Europeans referred to as customary international law, and which was already written, for example, into the statute of the International Court of Justice. The United Nations came with a very clever scheme, which was also approved by the African countries and the Asian countries. And that was the scheme of promoting the codification and progressive development of international law. And that was the first step towards the reform of international law. And actually, the modification and transformation of the law that was used in Europe in the 19th century and early 20th century, which was not international law, but a jus publicum Europaeum, or a public law of Europe, which was applicable only among European countries, in the same way that I said earlier, that there are all these conventions and agreements which are applicable only among African states, and to which some of the scholars refer as the regional law of Africa. That law at that time of Europe was actually a regional law of Europe. It was a regional law. And there was no universal international law as we know it today, because universal international law was born only with the Charter of the United Nations. That is when international law was universalized. And if anybody tells you that international law was universalized before the Charter of the United Nations, they do not know what they are talking about. And so the United Nations came up with this scheme of codifying and progressively developing international law. And it is actually that movement and that reform approach which brought in the Asian and African countries. But of course, everything was not codified or progressively developed. And you have to realize that when we talk about codification and progressive development, actually the two complement each other. Because with codification, you try to take certain norms, certain rules which existed before, But with progressive development, you don't take them in toto as a whole, but you change parts of them to adapt them to a new situation. And what was the new situation? The new situation was the total transformation of the international society. When the United Nations concluded the Charter of the United Nations, when the Charter of the United Nations was adopted, there were 34, 35 states which were member states. And by the time in the 1960s that the African and Asian states joined in, also the Caribbean states, the membership of the United Nations shot up to more than 100 nations. And later, of course, as we know today, to 194 member states of the United Nations. And so the international society which existed prior to the Charter of the United Nations did not exist anymore. It was a totally new international society, and the members of the new society, especially those that came from Africa, from Asia, from the Caribbean, came with their own legal perspectives. They came with their own approaches to international law and to the regulation of international relations, or to the establishment of rules which would govern relations between states. And therefore, they were not ready to accept in toto and as a whole many of the rules of general international law which governed relations between European nations. And so this is the beginning of the reform of international law. And since then, international law has evolved beyond the imagination of anybody at the time. Because when I talk about the Jus Publicum Europaeum, for example, just to give you an example, because I have to move on now to other considerations. When I talk about the Jus Publicum Europaeum, the Jus Publicum Europaeum was a type of regional law, and which was sometimes referred to as international law, which allowed for colonization of peoples, which allowed for oppression of peoples, which allowed for the repression of freedoms in other countries, which allowed for massacre, widespread massacre of peoples. And the Asian and African countries did not want to have anything to do with that kind of legal system. And so one of the first things which they claimed and which they advocated, which they had actually been advocating, for example, in the case of African peoples, since 1919, at the Paris Congress of the Pan-Africanist movement, was the right to self-government, which later became the right to self-determination. They had been advocating for that for over 50 years when they joined it and they became independent in the 1960s and late 1950s. And so one of the first things that was promoted by the Asian and African states at the United Nations was the outlawing of colonialism. And it was Resolution 1514, adopted by the United Nations General Assembly in 1960, which is usually referred to as the Resolution on Decolonization, that actually spearheaded and laid down the legal basis for that, for the outlawing of colonialism from the international legal system and the right of peoples to self-determination. And that has contributed a lot to the independence and to the emancipation of the peoples of Africa. So that is one set of legal rules. And it is not only the conventions and the customary norms which are accepted into the domestic legal order of African states, but when an African constitution says that they accept or they incorporate into their legal order or domestic law the general rules of international law, the question also arises with respect to the third source of international law, not only to the second, which I have just described it, but also to the third source of international law, namely the general principles of law recognized by civilized nations. And you must have all heard about that. What are the general principles of law recognized by civilized nations? And who are the self-styled civilized nations? And this is something that we still have in the statute of the International Court of Justice. And this is something that you will always have as a main chapter in any textbook on international law. But it is surprising, as I say, to see that this kind of source is also accepted to a large extent in some African constitutions directly. Because there is, for example, one or two African constitutions which actually refer to the norms of international law, the norms of international law. Now, the expression or the word norms does not only encompass rules, but it also encompasses principles. So are they going to accept the rules of customary law, which I had just been talking about? And on top of that, are they going to accept also the principles, the general principles of law recognized by civilized nations? And how would the constitutional judge or the Supreme Court judge of an African state deal with that? It's easy for us, judges of the international courts or of the world court, to deal with that because we apply directly international law. But how does a domestic judge deal with that when his constitution directs him to apply in the internal legal order of the country those kind of principles? I think this is something that we should all reflect upon. And of course, lastly, there are the subsidiary sources or the subsidiary means for the determination of the rules, which are the judicial decisions and the teachings of the most highly qualified publicists of various nations. Do you think that African publicists and the textbooks they have written on international law is included in that? This is also a question that I leave for your further reflection. So we have different, of course, types of constitutions in Africa. We have constitutions which are patterned on of course, most of the constitutions are actually buttoned on the constitutions of the former colonial powers. And this is our first problem as Africans, because I don't think that we have yet moved, except for one or two constitutions, like the Constitution of South Africa. I don't think that we have yet moved beyond the constitutional framework that was inherited from the colonial powers, because you can immediately identify and differentiate between the constitutions that are based on the French legal system and the constitutions that are based on the British or common law system. It's very easy. And most of the African constitutions are actually based on the one or the other. Of course, there are the constitutions that are based also on the Portuguese legal tradition, but they share legal tradition with the French system because both of them belong to the civil law tradition. So they are extremely similar. If you take the Constitution of Mozambique, the Constitution of Mozambique is very similar to the constitutions of French-speaking African states. But if you take the constitutions of Nigeria and the constitutions of Ghana, you immediately see that they are patterned on the common law approach. A common law approach which theoretically many scholars have characterized it as the dualist approach, while the other approach, which is based on continental Europe or the civil law tradition, has been characterized as the monist approach. But these are theories. These are general theories which are no longer valid, even in Europe, because there are no pure monist constitutions or pure dualist constitutions. Most of the constitutions actually today are a hybrid. So you see elements of dualism and elements of monism in many constitutions, although they are based, for example, on the common law approach, or they are based on the civil law approach. And I think in Africa, a very good example of that is the Constitution of Kenya, which has moved from the dualist approach of the common law tradition to some sort of a hybrid system, which brings it closer, I would say, to the monist system than to the dualist system. A monist system which sees continuity between the two legal orders, the international legal order and the domestic legal order, in such a way that they form the same legal order, and a dualist system in which the two legal orders are considered totally separate and therefore not subject to each other and not part of each other. So this being the constitutional approaches of African countries with respect to general international law, what are the constitutional approaches of African countries to the legislative enactment of the African Union? Nothing. They don't have anything in their constitutions, as I said earlier, which actually refers to these continental enactments, which are now more than 80 instruments, conventions, charters, treaties, protocols, you name it. And you would expect that after 60 years, the African Union itself would actually address this issue and say, but what do we do about this huge number of international instruments that we have adopted? What are we going to do about it? Because if you look at the 80 instruments that have been adopted, and I have looked at the website of the African Union, which is not, unfortunately, updated regularly with respect to all the instruments, because you find that some of the instruments have been updated up to 2019, and they have not been updated since then. Others have been updated up to 2022. Others have been updated up to 2023. But I think the 2023 is perhaps the latest date in which you find that this instruments have been updated. But based on those latest updates of the African Union and the website of the African Union, it is only about 36, let's say even 38 or even 40 of those instruments that have entered into force up to now. Imagine some of the instruments that were adopted at the time of the Organization of African Unity have not yet entered into force. Many of the instruments that have been adopted by the African Union have not yet entered into force. And worse than that, even if the instruments have entered into force, how many of them can we say are being applied and implemented in the domestic legal order? How many of them can we say? Not many, unfortunately. And I think it is because of that the African Union and African states, if they want to be true to the ideals of Pan-Africanism, if they really want to build a Pan-Africanist institution, Pan-Africanist institutions, and they want to build Pan-Africanist policies, approaches, Pan-Africanist legal frameworks which unify them and harmonize their attitudes toward certain issues, and also translate their shared values into legal norms and rules, then they should find a way of incorporating and ensuring that the instruments that they adopt are incorporated into the domestic legislation of member states. Because there's no point whatsoever, no point, just manufacturing, producing every year legal instruments which are not used, which are not ratified, which are not incorporated into the domestic laws of the countries, and which do not have, from an African perspective and from a Pan-Africanist perspective, which do not have a way which is unique to them, a way which is different as far as African states are concerned from the way in which they treat and they ratify and they incorporate into their domestic legislation international treaties, multilateral conventions at the universal level, which, as I said earlier, are really far, far removed in most cases from the daily preoccupations even, and daily lives of most African states and their peoples. It is the legislative enactments of the African Union that actually are closer to the lives, to the aspirations, and to the needs of African peoples and states. And therefore, those are the ones that should receive priority for application and implementation at the domestic level. They are the ones that should be given utmost priority. So how can we overcome this situation and make sure that the two sets of instruments are not treated in the same way. I think that there are two options that can be adopted by African states, and I would submit these two options for consideration. The first option would be for the African Union to consider adopting specific categories of treaties that do not permit reservations. There are some, actually, I should say not there are some, but that most of the legislative enactments of the African Union and Organization of African Unity have not been subjected to reservations. There are only, I think, about 7 treaties, conventions that have been subjected to reservations. But what is disquieting, what is worrisome, is that these treaties and conventions that have reservations by African states are actually some of the most important treaties and conventions adopted by the African Union as far as the public law of Africa is concerned. For example, the Human and People's Rights Charter, the Charter for Human and People's Rights, 2 countries have made reservations to it. The Charter on the Child, 4 countries have made reservations. Human and People's Rights Court Protocol, 4 countries have made reservations. Convention on Terrorism, Convention on Terrorism. Imagine, 4 countries have made reservations. Peace and Security Council Protocol, Peace and Security Council Protocol, 1 reservation was made. Convention Against Corruption in Africa, 1 reservation was made. Protocol on the Rights of Women, 3 reservations made. So I think the first measure that should be taken by the African Union is, first of all, to ensure and to bring the African states, while negotiating legislative enactments, to agree that the instruments that they adopt will not be subject to ratification. There are even many international conventions and treaties which do the same thing. So why can't African states do that? I'm quite sure they can do that. But more than that, I think that they can also agree that legislative enactments by the African Union should be automatically incorporated into the domestic legal systems of African Union member states. And there, they already have more or less an example, because there are the so-called conventions and treaties which have been adopted with what the African Union and the Organization of African Unity call it definitive signature. And these definitive signature conventions, but there are a few, very few, they are supposed to enter into force upon their definitive signature by the states, so that they don't need ratification of further legislative enactments at the domestic level. But I would actually recommend an approach which is similar, but not necessarily identical, but which is similar to the one adopted by the European Union. Of course, we know that the African Union and the integration of African states is not at the same level as the European Union. But I think African states and the peoples of Africa should be aspiring to that kind of integration, because otherwise Pan-Africanism would be a lot of hollow talk and hot air. And what the European Union has are supranational organizations, organizations that actually act and operate above the sovereignty of nation states or states, because those states and nation states have transferred part of their sovereign prerogatives of sovereign powers, especially in technical areas, to the European Union. So the European Union has the EU regulations, which become automatically binding and enforceable across member states without requiring national legislation. But they also have directives which require transposition into domestic law within a specified time frame. So the African Union could, for example, start with that and say, we have signed it, we have concluded this convention or treaty, and each member state should adopt it, should incorporate it into its national legislation within 12 months, let's say, within a specified time frame. At least until such time as African institutions attain supranationality and therefore become supranational organizations or supranational organs whose legislative enactments are directly applicable in the domestic sphere. So that's one option. The other option would be for the African Union to adopt model constitutional provisions, which would be recommended to all African states so that they would incorporate it into their constitutions, and which would actually give a fast track incorporation into national legislations of instruments adopted by the African Union. And I am putting forward these two options because I think that they offer, in a way, different approaches to African states. But I am also proposing these different options because I cannot imagine that African states should put into their national constitutions, but they do in reality. They do, but I find it difficult to accept or to imagine that they should put into their national legislations that the rules or norms of general international law or customary international law are part of the law of the land, whereas the legislative enactment of the organizations that they themselves have created have no place in their constitutional framework. No place whatsoever. They are not mentioned. That is what I cannot imagine. And that is why I believe an urgent reform and an urgent consideration of this differentiation. And that's where I started the lecture, of this differentiation between international legal instruments, universal legal instruments, and African legal instruments is not only necessary, but imperative. I thank you, and I will stop there.
Thank you, Judge Yusuf. That was an amazing lecture. And I have to say, everything you said made sense to me. We are extremely fortunate to have with us today the AU Legal Counsel, Professor Hajir Geldish. And it's wonderful to have these extraordinary ideas that you have obviously been thinking about for a very long time go directly to the Legal Counsel of the African Union. We have many questions for participants. I will get to as many of them as I can, but I believe it is important to now welcome and invite Professor Hajir Geldish to take the floor to comment. Hajir, you have the floor.
Thank you so much, dear professor, and many congratulations to you, Excellency Abdulqawi Yusuf. Really, I learned a lot all the time. I'm listening to your lectures, and I will be very brief to do 3 comments. The first comment, I agree with you on the issue of global law. Nowadays, there is a phenomenon of constitutionalism of international law and internationalism of constitutional law. And I think, as you said, there is eras or there is some standards or common understanding of levels of international law that Africans can meet and can have together. So when we see about the rule of law, the human rights issues, the environmental law, the investment law, trade law, labor law, the law of the sea, cybersecurity, I think we are at common understanding, and it is very easy to have what is called the global law. And I'm sure that the ones who read your book, it's about the Pan-Africanism and international law, you highlight these fields where Africans can have the same understanding and they can put together this issue of Agenda 2063 and integrism. Integration cannot come without our common understanding of standards of international law, and it is really easy to do it. And especially, as you said, we have a list of a lot of treaties of AU, OAU, but most of them are not entered into force, and this is political will that is almost lacking. So the second point I need to address is about the challenges. As you said, yes, we have the rate of ratification of the AU treaties is very slow, and this is an issue of dissemination. And I think what we are doing now in this week, it is one of the solutions. This is what we are doing. We are trying to put the light on our rules, on our treaties, on our specificities as Africans. As you said that there is not yet an African law, but it is an emergent international law in Africa, and we are building it. And this is also our role. It is about dissemination so that the political will come. Also, I fully agree with the issue of legal systems that are different. Member states in Africa, even if you said about monist, dualist, and hybrid constitutions, we are at least, even if we have different legal systems, we are in a manner or in another, we can go and we can overlap this issue of differences between the legal systems, because now we can ask each other and we can understand each other. And more than that, we didn't address the model law and the role of some organs of the African Union who are at least doing something to push the member states to this idea of domestication. So if I can resume, or if I can just have methodologically speaking, after dissemination come the accession and ratification. After that come the implementation. And the last thing is domestication. So to have domestication, African Union has some organs who can facilitate the work. Among these organs, we can find AUCL, the African Union Commission on International Law, and I refer to the statute of AUCL, especially the Article 4. They have the role and the mandate to propose draft frameworks, agreements, or what is called the model law, and they are doing well because they have already done the model law on IDPs, and there is still studies on model law on protection of women and children. Also other organs, and especially Pan-African Parliament, they have a role in this issue of domestication, especially by reflecting some model laws, and they have their Article 4D and the Article 11.3 of the protocol of the PAP, where it is said the PAP has as mandate to contribute to the harmonization and coordination of the legislative texts of the AU member states. So this is an organ that has a possibility and the arena and the tools to do that, to harmonize the legislative text, especially, as I said, in some fields that are of common understanding. And in practice, even other organs can initiate, especially the AUABC, this African Union Advisory Board on against corruption, what is called the Commission of Banjul. So these organs and other departments within the AU, they have the possibility to initiate model laws, and this can really, even if you know very well that the model law is not binding, however, it can give it is just, and here Judge Ben Kyoko, I refer to the 2011 when you did a wonderful in Midrand, South Africa, you have a wonderful seminar to say that model law are there that are not binding for the AU member states in any way, but they are intended to be used and adapted by states to suit their needs while enacting domestic legislators. So I think, again, just to recap, that African Union has a role and they are doing well. However, the last resort should be the member states. This is an idea of political will. And the consequence will be that the background of our lawyers, of our advocates, of our judges, of our ambassadors can be embittered, because if you have this capacity building, this regular, this periodicity in knowing our rules, our instruments, you are in a way able to push and to develop the jurisprudence and the other corpus, so that you can refer all the time to our public African law. So I think it's a whole. This is a holistic manner to address the issue and the question of domestication of AU and OAU treaties. It is not only the role of African Union or the member states, but I think everyone has something to do, and it is good that we finish this seminar with the question of domestication, because the domestication is one of the issues to make it better and to push for understanding better, and to let our core rules at least understood, eligible, and possible for our parliamentarians to go forward. So I think this issues, I didn't listen very well on this. Maybe it can be a complementary. I think that the model law and what the AU is doing in different issues, especially in human rights, is very interesting and very important. And it is up to the speakers maybe to add if they have any other propositions or recommendations, because we are here also to think about the future generation and how we can improve this issue and these challenges dealing with domestication, ratification of international law at the level of African Union. Thank you so much.
I will get to as many questions as I can. As you know, I usually take them in chronological order, and I usually limit one question for each participant. These questions were actually sent to me by a student in Angola who sent the questions the same day that she registered for the seminar. So you may want to think about that for the future. First question, how does the lack of ratification by some countries negatively impact the effectiveness of regional treaties and continental integration?
It does effectively, actually it reduces to zero the effectiveness of the treaties and conventions adopted by the African Union. Because if they are not incorporated into the domestic legal system, they have absolutely no role whatsoever to play in the domestic legal order of those countries. So it undermines their effectiveness. Thank you.
Next question. To what extent are national parliaments prepared to evaluate treaties and ensure they serve national interests?
I hope they are. I hope they are. But you know, we know some very disappointing examples in which national parliaments in Africa adopt actually not African and ratify not African treaties and conventions, but international conventions and treaties which have not been properly analyzed, properly debated in parliament, and properly considered in the country. There was a young African researcher who tried to find out, because when a international treaty is ratified by a country, you can always find the travaux préparatoires or the debates in parliament regarding such an international instrument. He could not find a single trace of debate in any African parliament regarding the International Criminal Court and the Rome Statute, because African states were all of them complaining about the fact that in the International Criminal Court was focusing on Africa, that it was unfair, that it was only Africans that were being indicted by the International Criminal Court or investigated by the International Criminal Court. But the largest number of countries that had ratified the Rome Statute were African states, and he could not find any debate in any African parliament on the ratification of the Rome Statute. So definitely, this is something that's lacking in most African parliaments, and it should be done.
It's interesting. As you may recall, I worked on the Rome Statute, and there was a very large, very powerful coalition to bring that statute into effect as quickly as possible. I'm not aware of any counterpart in Africa where NGOs really push. It's in some instances it may be true, but this is something that people may want to think about. So I have to use my phone, which has the translation of the questions. You mentioned the European Publicum as an instrument of legitimizing a Eurocentric normative domination. From this perspective, do you think it is possible or even desirable to develop a common African public law? I think I know your views on this. For example, through the progressive codification of African Union treaties, without risking the reproduction or the duplication at the continental level of a rigid unification logic that would obscure the plurality of African legal traditions, such as customary law, orality, or Islamic law. I have asked the participants to be brief in their questions, so that's a rather long one.
Yes, I wouldn't wish on African states the type of public law which existed in Europe, or at least those aspects of it which were aimed at dominating other peoples, at colonizing other peoples, at repressing other peoples, at enslaving other peoples. I wouldn't absolutely wish an African peoples and nations have been struggling for a long time to fight those kind of tendencies in international relations and to get rid of them. I think that the public law of Africa should be a public law which should actually promote freedom, which should promote well-being, which should promote development, which should promote governance based on the will of the people in Africa, and which should promote also good faith establishment of relations with the rest of the world, based, of course, on respect, reciprocal respect for the nations involved. And I think those are the basis on which we can build the public law of Africa. And we have already made a start with a number of charters that have been adopted by the African Union, but they need to be implemented. They need to be applied at the domestic level.
Perhaps I could mention here that Judge Yusuf gave a lecture on the public law of Africa during the first African law seminar series that was held last April. I am working very hard with my colleagues at the African Institute. We are building a website. We will be making these lectures available. And so I would invite all of you to watch his very interesting lecture on the public law of Africa as soon as we can get it uploaded. Next question. Why were the Europeans able to agree on unified rules while African countries, due to their fears and political contexts, remain stuck in place?
Well, actually, we expected that because of the history of Pan-Africanism and because of the common and shared values among African nations and peoples, when the 1958 conference of the first group of independent African states was organized, and they actually, all of them agreed on an African personality, which should be reflected on all common policies of African states. We thought that African states actually would move to integration, would move to closer economic and political cooperation faster than perhaps their European counterparts. But unfortunately, there are always external factors, and I am not ruling out internal factors, because internal factors also exist. But there are always external factors that contribute to a great extent to divisions among African nations. And those have played a part in the fact that African states have not moved as quickly as one would have wished to closer political and economic integration.
Next question. How should national legal systems differentiate between African Union treaties and global multilateral treaties in terms of domestication, given their distinct regional objectives, enforcement mechanisms, and legal traditions?
African constitutions already have provisions with regard to international, universal, and multilateral treaties, and therefore they don't need to do anything but implement those constitutional provisions. But they need to include in their constitutions special provisions which concern the domestication, the integration of Pan-African conventions and treaties into the domestic legal order, because that is the gap which exists now. And I personally believe that the two sets of legal norms cannot absolutely be treated in the same manner. They should be differentiated.
Next question. In what ways do the normative priorities and enforcement frameworks for AU treaties, for example, the Maputo Protocol of AFCTA, require unique strategies for legal harmonization compared to treaties from the United Nations or the World Trade Organization?
Well, I think that I have already commented on that, and I think it more or less repeats what some of the other questions were about. It is a Pan-African instrument. These are Pan-African instruments, and they should not absolutely be equated to multilateral or universal instruments. We need to treat differently the Pan-African instruments. Otherwise, there is absolutely no point adopting Pan-African instruments that will be treated in the same way as the Montego Bay Convention by all African states, you know, and it will take ages sometimes before these African treaties or Pan-African treaties are integrated into the domestic law. And that's what has happened up so far. Because as I said earlier, there are only 36 conventions out of 80 that have been so far, that have so far entered into force, which does not mean that they have actually been adopted by the majority of African states. No, most of them have entered into force with only 15 or 20 ratifications. So only 1/3 of African states have actually ratified most of those that have entered into force. And that is really something which is totally inadequate and inappropriate for the domestication of African legal instruments.
Next question. It...
Virginia, I have 5 more minutes. So
okay, 5
yeah.
more minutes. Okay,
Yeah.
then this is the last question.
Okay, very good. Fantastic. Fantastic.
Okay. Is it possible to believe in the existence of a community of African values intrinsically, while omitting the historical approach of public international law and the domestic law of states as distinct legal systems?
One thing is the community of values. The other one is the community of legal systems. They are different. You know, not all common values are translated into legal norms. Sometimes states are able to translate certain primary common values into legal norms, and sometimes they fail to translate such common values into legal norms. That's natural. But the most important thing, I think, is to identify the common values. What common values do we hold together? And I think that, as far as African states are concerned, it can be found in Pan-Africanism. And then, of course, how to translate those common values into legal norms which we can all apply, and apply immediately, not apply in 30 years or 40 years, because absolutely there is no point adopting a convention today. And some of the conventions I mentioned were adopted 30 years ago, but they have not yet entered into force. So there is absolutely no point adopting conventions which do not enter into force in 30 years or 35 years. So I think that there are common values, a lot of common values, because otherwise we would not even have had this Pan-Africanist institutions. But we need to learn how to translate them into effective legal norms, into effective legal rules, which are implemented and applied at the domestic level.
Judge Yusuf, it was a pleasure to have you join us. Your lectures are always very powerful and thought-provoking. I look forward to welcoming you back for your next lecture on Monday, the 15th of September, when you will be speaking about Africa and the International Court of Justice. And I hope that you will be able to join us for the last African Law Seminar of the year, which will be the week of December 1st. I appreciate the comments that Hajir made today about the usefulness of these seminars. We are having 4 per year. And we have 2,500 participants who have signed up for this. And we are also welcoming participants from all 55 AU member states, which I think is wonderful. Judge Yusuf, can you wait 1 minute? Ben Kyoko is coming in.
Yeah.
Ben, yes, you have the floor.
Yeah, please allow me to thank Judge Yusuf, whom I've not met for quite some time now, for the very, very powerful presentation that he made. And Judge Yusuf, just to say that in my view, the biggest challenge on the continent and the issues that you have highlighted is because of lack of political will. And Professor Aja, I'm sure, will agree with this, that the problem is lack of political will. And it cuts across all the issues relating to treaties, from the period of negotiation to adoption to ratification to implementation. And just to give you an example, you also find states that would rush to ratify the UN conventions and leave out the AU ones. One example is the UN Convention Against Corruption, which was adopted about 6 months after the AU one. And in fact, the AU convention was used as the negotiation tool for the UN convention. But then you find states that went ahead to ratify the UN convention, but did not ratify the AU convention. And yet it addresses the issues of concern to the African continent. And also this issue of reservations, there are quite a number of examples where there are treaties that the original draft did not have reservations, but somewhere along the way during the process of ratification, a reservation was introduced. And this idea of 15 instruments being required in the original treaties that were adopted under the OAU, most of them required 2/3. And then it was observed that it was impossible to obtain 2/3 instruments of ratification for member states. And therefore, that's where there was that shift from 2/3 to 15 instruments of ratification. On model laws, there are quite a number that have been developed. There was one on application of universal jurisdiction, a national model law, another one on terrorism, another one on refugees, and as Professor Aja mentioned, another one on IDPs. There are quite a number. But at the end of the day, you find that the states do not take the necessary measures to implement those treaties, in spite of the fact that Article 23(2) of the Constitutive Acts provides that any member state that fails to comply with the decisions and policies of the Union may be placed under sanctions, including the denial of transport links, etc., etc. So there is a provision which says member states have an obligation to comply with the policies and decisions of the Union, but they still don't do so. I know you are leaving. I don't want to talk too much. Yusuf, glad to see you again. Professor Aja, nice to see you again too. Thank you.
Ben, before you go, I would like to, and Hajir, thank you for coming on the screen. I would like to tell the participants, you have had the opportunity to listen to 3 legends in one meeting. This is amazing. Of course, you all know Judge Yusuf, you know Hajir. Ben Kioko is the former AU legal counsel. He built the bridge from New York to Addis Ababa for me so that I could establish the permanent regional course. He is also former judge and vice president of the African Court of Human and People's Rights. He was one of the main drafters of the African Charter on Democracy. He was the one who overcame the legal and political hurdles and got that historic agreement signed. And I'm delighted to tell you that Ben will be joining us to give his lecture on the AU Charter on Democracy on December 1st. And I'm still hoping Judge Yusuf will join us for that one as well, because we've talked about perhaps he will give a lecture on the AU response to unconstitutional changes of government, which is, of course, very important. So, Ben, thank you. I'm delighted to see you. Judge Yusuf, I have a feeling you've left. Thank you. This concludes the second African Law Series online seminar devoted to the ratification of African treaties. I hope that this seminar has been an educational and inspiring experience. In my view, every African lawyer and law student has an inherent right to knowledge to achieve his or her full potential, and in particular, knowledge of African Union law to contribute to the goals of the African Union and a better future for the peoples of Africa, beginning with doing everything you can to promote the ratification and entry into force of the treaties that we have discussed this week that are so important for Africa. Thank you for joining us for the seminar. I look forward to seeing all of you and your colleagues next September. Goodbye for now. Thank you.